Welcome, welcome Fabio Marcelli for taking part in our interviews with Medya News. Let's go with the first question. You had contact with the Azrin Law Office and other law NGOs in Turkey. Based on your experience and based on those contacts, how would you evaluate the current state of legal protection in Turkey, particularly concerning prisoners' rights and freedom of the press?
Yes, I had many experiences in the Turkish legal systems. Me and my colleagues of our association, the Center of Research and Elaboration for Democracy, CRED, had the occasion to visit Turkey in many occasions and to observe trials as international observers. We observed the trials against the lawyers, the trials against some politicians, especially members of the party which was at the time was the HDP party. Now I think the name has changed. We observed trials for the murder of lawyers, like the trial in Diyarbakir for the killing of the president of the Diyarbakir Bar Association, Tai Elchi. So we have a record, a considerable record of experiences concerning the Turkish legal system. And of course, our evaluation is very negative because we think that the Turkish legal system, and in particular the Turkish judicial system, lacks of independence. There is a direct control by the political power on judges, because judges can be changed whimsically by the political power in every occasion, so they don't have a real power to decide following the norms to be applied. So it lacks this essential feature of the independence of the judiciary, and of course, for this reason, it cannot be considered as a system where rule of law operates. Moreover, there are other aspects which concern the possibility to judicialize also expressions, freedom of expression. There is a strict control on freedom of expression, which should be following the United Nations Covenant on Civil and Political Rights, a fundamental element of all legal system. And Turkey, of course, decided to enter in this covenant of 1966 on civil and political rights, as well in the European Convention for Human Rights and Fundamental Freedoms and other international treaties concerning human rights, and in particular the freedom of expression, which are constantly disattended by the Turkish authorities, which judicialize people only for expressing their opinion. And this is a violation of international law, of course.
Thank you very much for your answer. Let's go on with the second question. A new 3-month disciplinary sanction was imposed on Abdullah Öcalan following a recent prison visit from his nephew Ömer Öcalan, who is also a Dem Party member of the Turkish parliament. This visit was the first visit to happen since March 2020. The solitary confinement imposed on the PKK leader is incompatible with Turkey's law. How do you assess this illegality?
Well, I have to say that this situation is completely new to me. I didn't know that this 3-month disciplinary sanction was imposed on Öcalan following the visit by his nephew. And I find it very strange and puzzling because I suppose this visit was authorized by the Turkish authorities. Otherwise, it would have been impossible for the nephew of Öcalan to reach Imrali and to have the meeting with his uncle. So I wonder why this sanction was imposed. Clearly illegal sanction. In my view, it could be. I don't know. I would have to assess more precisely the circumstances of the case, but it appears to be a patent contradiction inside the Turkish legal and political system. This is to say that there are divergent views inside the government, inside the political parties who suppose the government of Mr. Erdogan, and so on. There are different views on the relationship to install with Öcalan, and therefore there are these kind of strange attitudes. I repeat, it's very strange. I don't know very much on this case, but it seems absolutely unbelievable that a visit is allowed, and after the prisoner is imposed a disciplinary sanction because of the visit. It seems to be a completely schizophrenic attitude by the Turkish state. We should understand better why there is such a schizophrenic attitude.
Thank you very much. Let's go on now with the third question. In a recent interview, you addressed the conditions of Öcalan's detention and said that a new appeal to the ECHR, the European Court of Human Rights, is necessary in Öcalan's case. Recently, the Council of Europe requested Turkey reform in its law on life imprisonment and implement the right of hope, giving a deadline of 1 year for legislative amendments. Do you think that the increased pressure on Turkey could lead the result concerning the rights of prisoners and Öcalan's isolation?
Yes, we hope that a new decision of the European Court of Justice will contribute to improve the situation. On the other hand, I think that this decision is necessary because if you refer to the decision adopted in 2014 by the European Court of Justice, this decision said that there had been violation of the European Convention of Human Rights on Human Rights, Article 3, prohibition of inhuman or degrading treatment as to the conditions of Mr. Öcalan's detention up to 17 November 2009, and that there had no violation of this article as regards the condition of his detention during the period subsequent to 17 November 2009. So far I know, the conditions now are rather similar to those existing before 17 November 2009. So there were many steps back, especially concerning the fundamental issue in this case, which is the issue of solitary confinement, which is called in cause also by the case of the recent visit of the nephew about which we have now talked. So these conditions should be newly assessed in the light of the present situation to verify if there is a violation of Article 3. I repeat, substantially the issue in discussion is the issue of solitary confinement, which is following the jurisprudence of the court is in violation of Article 3. If there is solitary confinement, as I think there is a violation, and Turkey should adopt a different line to this regard. So we hope that this new decision of the court to be requested through an appeal will change the situation and will improve the condition of detention of Mr. Öcalan, rendering them compatible with the European Convention on Human Rights, especially its Article 3.
Thank you very much also for this answer. Let's go on. Let's go to question number 4. We can see in conflict zones around the world, the human rights are rapidly being eroded and international laws of war violated. Israel's war in Gaza and the Turkish army's use of chemical weapons against Kurdish guerrillas are two examples. Although the violations are deemed illegal according to international humanitarian law, they continue. Juridical pressure is important, but what other activism would enforce court decision and respect of human rights?
Yes, of course, we are facing now a catastrophic situation in many places of the earth. Probably the worst situation is that of the genocide of the Palestinian people, which is being executed by the Israeli government of Netanyahu, but there are also other cases of violation of the rule of the law of war, violation of international humanitarian law. I think that every effort should be made in order to change the situation, to restore the application of international humanitarian law. I think that an important role could be played in this situation by international alliances of different states. For instance, there is now the coalition of BRICS, to which also Turkey is a candidate, which adopted recently a very important declaration in its meeting of Kazan a couple of weeks ago, in which they attribute importance also to this kind of question concerning international humanitarian law and human rights. I think that the pressure should also be exerted politically, asking all the states and states coalition which are interested in reestablishing an international order based on law to demand by United Nations and by the states which are violating these laws to adopt a different attitude. I think international pressure is very important. It should be exerted combinedly at legal and political level. And of course, also movements of opinion and so on have a great importance if they are apt to stimulate such positions by the states.
Thank you very much. In order to close our interview, I would ask you if you have a final message that you want to leave, or a topic or a statement that you want to leave.
Yes, myself, I am following since a long time the situation in Turkey, referring to the problem of democratic forces, to the repression of lawyers, to the Kurdish questions, and many other aspects. I think that Turkey could offer us today the example of a country which is wishing to go another path, which is not a path of repression, it's not a path of violation of human rights, it's not a path of internal war, of civil war, but it's the path of dialogue, peace, and mutual recognition of the rights of the different part of the Turkish population, of the different organization, and of the very important role played by professionals like lawyers, but also, for instance, physicians, intellectuals, academics, trade unionists, and other sectors of the society. So I think every effort should be made in order to give a solution to all this very important and very old question, in order to pave the way for a new Turkey, which will be an example so also for many other countries in the world.
Thank you very much, Professor Fabio Marcelli. Thank you for being with us this evening. And good evening. Thank you for joining.
Thank you. Bye bye.